My name is Dave Kessler. I'm an attorney at law, and I own the law office of Dave Kessler and Associates. And we do civil litigation, workers' compensation litigation, and we go to depo. And we take depots and we give depots. And this is really made for my clients who are about ready to go to a depo, and maybe they're a little nervous and as to the depo going forward. So I've made this video so they can kind of get the mechanics of the depo, so they'll feel a little bit better. Once you get in there and you start understanding what's going on and having this depo as a background, you should feel a little bit more comfortable. So a depo is an informal answering questions session where the opposing party gets to ask you questions, and this is done usually in front of a court reporter, and sometimes it's videotaped. Her job is to take down everything that's said, and she doesn't take down nonverbal. He or she doesn't take down nonverbal responses, so it's important to verbalize your response. You can shake your head, but if you're going to say no. You're not just going to shake it, and you can yes. The pointing to body parts, for example, if you want to point to something that hurts or something like that, then you need to say, I'm pointing to it. If you do this and you don't say it hurts right here, I'll say, let the record reflect that the opponent is pointing to his or her nose, and I'll say to the opponent, is this correct? And you can say, no, I wasn't really pointing to my nose, I was actually pointing to the bridge of my nose, and I'm sorry for the misunderstanding. Or you can say yes. Now, the court reporter will type everything that's said, and at the end, they will put it into a booklet and they'll give it to you to review and give back to them. When you review it, you have the right to make changes. So you can say, no, the car wasn't black, it was red, and make the changes and give them back to me, and I'll give them to the court reporter and the opposing counsel. What's important for you to know is the defense counsel is going to tell you, well, if you make changes to the depo that are material, I have the right to comment them at the time of trial. And that may adversely affect your credibility. Yeah, maybe. It depends on your testimony and how truthful you're going to be. I would say that if you gave testimony and you went home and you talked to somebody and you were talking about the testimony you gave, and that somebody said, don't you remember? That's not how it happened. It happened this way. It was a red car, not a white car. Remember, the white car was the one that came just before it, and then we didn't really see the red car until we were on the ground. And you go, oh, well, that's right. I don't know how I got that wrong. It must have been all the anxiety and fear I still have from that accident. And then you make the changes. And at trial, defense counsel goes, well, you said at deposition that it was a white car, and you later changed your story. You're not a good, you're not giving good testimony. And then the response would be, well, it's true that at the deposition, I didn't give you that, but I went home and I talked to somebody, and I realized I was wrong, and I wanted to correct it. They may go on to try and prove other things with regards to your testimony, but I don't think that that's damaging. I think that that's fair. Most of my clients this is their first time in front of, in a legal setting. They're not used to it, and they get a little scared, or they don't realize the questions are going to be asked. And they don't remember. They don't know what to expect. So and sometimes defense counsel goes off into the woods and starts asking questions that have nothing to do with the deposition, the lawsuit, or whatever the depo is about. So just keep that in mind. You also need to know that defense counsel's job is to ask questions. And they're going to ask you questions, a lot of them. And it's not going to be a informal setting. It's going to be a formal question and answer session. He or she controls the question. You, the deponent, controls the answer. Well, what do we want to do? We want you, when you give an answer, to give the most credible answer you can, demonstrating that you're a very credible person. That's important because when you get in front of a jury or when they're evaluating the case, they're going to think about your deposition testimony, and they're going to say, well, as far as the deposition testimony goes, this person should be believable. The way we maintain our credibility is we give good answers to the questions that we understand and know the answers to. And to the questions we don't understand or we don't know the answers to, we say so. For example, if defense counsel asks me, what is the radius of a circle that has a 3-foot circumference, I'm going to answer, I don't know the answer. I'm not going to try and play a mind game. I'm not going to try and get them to ask me other questions so that I can find a clue. My response to a clue to the answer, my response is going to be, I don't know. And that's exactly what the answer should be. If he says, you worked for some person who I never worked for, and you were hurt at that place, isn't that true? I'm going to say, no, that's not true. If he says, you slept on, that the reason that I'm hurt was not because the car ran me over, but because I was thinking about monkey lips and slipped on onion pills, my response is going to be, I don't understand the question. That sounds really goofy to me. I understand the words, I understand the structure of the sentence, but can you repeat that one more time? Because if it is what I think you said it is, then you're crazy and there's a problem. The thing you don't want to do is you don't want to do what one of my clients did. And every time they asked him a question, he would say, I don't know, or I don't understand the question. And it went something like this. Sir, isn't it true that you recently moved? Yes, I did recently move. Okay, and you hurt your shoulder prior to the move, correct? Yes, and how would you rate your shoulder? Same, better, or worse since you hurt your shoulder? Oh, it's much worse. Oh, horrible. Okay. So you moved from one house to the other. Did you pick up any of the furniture? Oh, I don't remember. You don't remember if you picked up any of the furniture? I don't understand the question. Well, when you move, you have stuff in one house. Did you take that stuff to another house, to your new home? I don't remember. You don't remember if you bought new furniture or moved your old furniture. How long ago did you move, sir? 2 months ago. Have you ever driven a truck? No, I don't have a truck. Wasn't the question I asked you. The question I asked you was, have you ever driven a truck? I don't know. I don't understand. I mean, I don't have a truck. Sir, you cannot have a truck and you can drive a truck. Does anybody in your family have a truck? Oh, I'm not sure. Okay, well, do you know anybody with a blue Nissan pickup? Oh, I think my son has one. Have you ever drove his truck? I don't remember. 2 months ago, did you drive your son's truck? Maybe. I'm sure I understand the question. And it went on like that. Come to find out, they had all kinds of video of the guy driving trucks, picking up furniture, doing lumber stuff with the arm that he said he could barely move. The other kind of instance is where you have somebody who claims that they can't do anything because of their injury. And it goes something to this effect. Do you have any problems with because of your injury? Oh, I ruined my life. Ruined my life. How did it ruin your life? Well, I used to be a chef. I used to go surfing and I don't know, ceramics. I used to make pots and flower pots and ashtrays and whatever. Okay, and where did you do that at? I did that in Santa Monica. Okay. And did you live in Santa Monica at the time? Yes, I lived in Santa Monica. Where do you live now? I live in Bakersfield. Okay. When did you move to Bakersfield? 2010. Okay. When was the last time you went surfing? Oh, it was in 2010. Okay. And when was the last time you made pottery? Oh, that was in 2010. Okay. When was the last time you performed any type of chef type of duties? Oh, that was in 2010. Okay. And then when was your injury? 2014. Well, right there, you know that there's a problem because the evidence or the facts demonstrate that in 2010 she stopped the activities that she claims the accident stopped, and she was hurt in 2014. So these two things, they conflict with each other, and she's got to fix that, or he's got to fix that. And there's not a whole lot of way of fixing that. Um, and it's better if you just stick to the truth of the matter. And defense counsel will just keep asking you questions. The other one is one I've seen a couple of times. And it kind of cuts both ways. At first, it's going to seem, when I start to explain it, like, wow, this guy that I was seeing in depot was really full of it. And then later you'll say, well, maybe not. So we started depot. And during the deposition, like within 5 minutes into it, the defense counsel asked, it was a workers' comp case, asked the applicant, how long can you sit down for in a chair? He says, oh, I can only sit down for 5 minutes, 10 minutes tops. My back is killing me. I got to get up and walk around. So we went on and we talked about where he lived for the last 5 years, his work history for the last 5 to 10 years, any prior histories or any kind of medical history for the last 10 years, any slip and falls for the last 10 years, including car accidents, and prior workers' compensation claims. And we were about an hour into it, and he goes, well, sir, would you agree with me that you've been sitting in that chair for an hour? And he goes, yeah, I agree. And you agree with me that 5 to 10 minutes into your depot, you stated you could only sit in that chair for 10 minutes max, and you'd be in a lot of pain. Is that not correct? Yes. Okay. And then he went on with the depot, and then it was my turn to ask him questions. And normally I'm not going to ask questions in a depot. I'm going to allow defense counsel to ask questions, and I'm going to walk out. The workers' compensation claim, because the depot plays into the QME and AME situation, I'm going to ask a lot of questions. So what I'll do is I'll wait. And then I went and talked to him. And I said, well, what's 10 minutes? We got a problem, man. You sit in that chair for an hour, and it doesn't look good. You don't look credible. You're decreasing your credibility. And he said, well, that chair is awesome. And I've never been so comfortable since I've had my back injury. I don't know what that chair is, but I want to take it home with me. So I get him back, and we get back on the record, or the court reporter's typing. And I said, okay, sir, so you testified when defense counsel was asking you questions, you could only sit there for 10 minutes. The fact is, you've been sitting in that chair for an hour. Why is that? And he said, well, this chair is extremely comfortable. It supports my back. It's got this thing here. The way the arms are, they're this perfect. My feet are right on the ground. I am comfortable, and I can't believe it. I am actually feeling good. I feel I still have pain, but I feel less pain, and it feels really good to be in the chair. So, sometimes you get a gotcha moment, and it turns into a I got defense counsel moment. You also need to know that defense counsel, well, I don't want to pick on defense counsel too much. Normally, communication is an imperfect medium, meaning that I have a thought of what my question conveys, and you have a thought as to what your answer conveys. And the two may be so far apart, but be the right answer and the right question, that it's hard to tell. That the listener hears one thing, and the speaker says another. And you'll hear defense counsel do this sometimes, and they'll go, well, that's in contradiction to what you said. And I always tell my client, if it gets to that point, you don't have to clarify. It isn't your job to clarify your answer. It's their job to clarify their question. So if they sit there and go, well, I asked you this and you said X, that means this, that means Y, and you go, and you're in your mind you go, well, no, it doesn't. It means something different. You just don't understand my answer. Then your response is, well, that's not the way I meant it, or that's your interpretation of what was said. Then what will happen is either defense counsel will slow down and break it down for us, or we'll just, they'll just consider you to be a bad witness. And that really plays against them, and they should be a little bit more wise to it. Normally they're not hot, huffy, I guess. They're going to take it a little bit slower and try to understand it because they don't want to get it wrong. But I've been in depositions where I've had people start yelling at me, and my response is, well, you can do whatever you want. I'm not going to get it crazy over this depo, and if you can't take the time to be intelligent and reasonable, it's on you. So I think I covered it all with regards to that. The most important thing is to do your best and not to try to take on the responsibility of interpreting a question when you have to strain yourself. You're supposed to give your best testimony, and you're supposed to answer the question the way you understand it. And if you do those things, you should be all right. You can take a break whenever you want to. If you need to stand up, you can stand up. If you need to lean against the wall, you can lean up against the wall. If you need to lay down, you can lay down. If you need to go to the restroom, go to the restroom. If you want to ask me a question, usually you have to, if there's a question pending in workers' comp, you can probably get away with saying, hey, listen, I want to ask my lawyer a question. And in civil litigation, you probably aren't going to get away with that because you're not supposed to have the benefit of your lawyer advice on how to answer a question. I'm just there to protect your rights. And what you'll hear me say is you'll hear me sometimes object to the form of the question. Objection vague and ambiguous or broad calls for speculation. Goes beyond the witness's knowledge. Requires an expert testimony. Asked and answered. Violates the Fifth Amendment right not to self-incriminate. And then when you hear me saying it violates some kind of privilege, you'll hear me tell you or instruct you to not answer the question. For example, violates attorney-client privilege, don't answer the question. There's not going to be a lot of argument, because you can't sit there and have what's called a speaking motion, because it can be interpreted as being disruptive. I can't be disruptive. I have to allow them to ask questions. So it'll be something quick, and you may want an explanation of what's going on, and later you can pull me aside and I'll explain it to you. That's what I get paid to do. However, during the depo, that's not going to happen. Now, defense counsel is going to say to you, or may say to you, hey, your attorney just told you not to answer the question. Are you going to follow their advice? And you can say yes or no. And that's a fair question, and I think that's a smart question, because I can't tell you what to do. I can only advise you what to do. And to check my advisement is an interesting concept. You may get some client that says, no, I'm not going to follow his advice, and here's the answer, which makes the attorney's job harder. Just as a tangent, as an aside, my job is to protect the privilege. I'm there to guard it, but I don't hold the privilege. I'm sort of like the guard dog in the yard. I will bark and bite anybody that comes in the yard. But if you put me away, you're going to bite anybody in you want. And that's what he's saying. That's what the defense counsel is attempting to do, is to see if you're going to put me away and invite whoever you want. The objections as vague and ambiguous, overbroad, calls for speculation. You still have to answer those questions. There's been no ruling on those questions, as there's no judge. At the time of trial, if they try to bring up that testimony, then the judge at that time will have to consider the objection. There, asked and answered questions are, if you don't want to answer the question and you've already been asked the question, you can just say, I've already asked that question. I want you to, and they go, well, no, I want to hear your response. Then you can say, well, you can have it either read back from the record, or you can have it read back to me so it can refresh my memory what my answer was, and then I'll tell you the answer over again if that wasn't good enough for you. That's pretty much it. I think that should get you through a depo. Now, what you and I will do, this is just the mechanics of a depo, how it works and the things that go on. Then you and I should sit down and go over the facts and have an understanding of what the facts are, and refresh your memory as much as we can as to what's been going on and the reason why we're there, and maybe correct any mistakes that may be in the pleadings or in the litigation. Thanks a lot. If you have any questions, please give me a call, and I hope you have a very credible deposition.